Hi, hello, welcome to every Wednesday immigration show with Lucas Garrison. So everyone know we are trying to give the simplified USA immigration to all Indian community or immigration community. This will continue every week, Wednesday 6 p.m. Central Time, and we keep trying to update the latest updates. What happening this administration, US administration. Today is the new day for American and the immigration community. Joe Biden and Kamala Harris took sworn the new journey. I think look like just we received the very good news. Lucas will share what is the good news for everyone. This is really very happy news for everyone. So we can first we congratulations to Biden and Kamala Harris. The Kamala Harris is a historical first woman vice president. We congratulations to both, and we will welcome to Lucas today Wednesday immigration show. Hello, Lucas. Good evening.
Hi, Venkat. Thank you for having me. It's a pleasure to be back on the forum this week.
Yeah, thank you. Thank you very much. So, today is the new day and new journey for American and immigration community. So, what do you think? Maybe you can share your happiness.
Well, I mean, I think it's really a great change from what we've been going through for the past 4 years. And we all know anyone who has anything to do with immigration, either as an individual who lives through the process or an attorney or anyone else who supports any of this process, you know, we all know how much of a headache we've had this past 4 years, and stress and difficulty making sure that everything is taken care of. But, you know, so really good news. You know, we know, obviously, Joe Biden is president. He was sworn in today and went to the White House and immediately issued 17 executive orders, reversing quite a bit of what Trump had done or not done in regards to like the coronavirus, response. And today, I'm pleased to announce that President Biden has suspended President Trump's implementation of certain programs. Travel restrictions like the Muslim travel restrictions has been rescinded. United States has now rejoined the Paris Climate Accords. And so all these other, harmful regulations that were set to take effect have also been frozen for 60 days pending review from each agency.
Yeah. Okay. Thank you. Yeah. Today we can discuss one by one, and we will go with very detailed information. The topic. The first thing, we know that the Trump leaving to his presidency still is implemented a lot of complicated the rules on immigration, the community. The first one is the DOL and DOL and DHS Final Rule. So it means, as per my understanding, is even they included to end client to LCA and end client to need to apply the H1, but I don't know how it will implemented. But I think you have a very good news on this one. You can share about the DOL and the DHS, the final rule.
Right. So the final rules have been, like I said, suspended. They're frozen right now until pending review. Now, just to give everyone a little bit of background of what this means, there's certain things that a president can issue as far as like an executive order or a proclamation, such as a travel ban or other things. And more of a permanent rule would be these, at first the IFRs and now the final rules from DHS and DOL. And the new administration obviously does not support these rules, but there's still certain procedures we have to follow to rescind them. So again, everyone remembers last fall we had the excitement with the IFR. Wage levels went up. We also had expectations in December of possible one-year approvals for H-1s, all these other requirements for third-party offsite employment, right to control, among others. And those were thrown out by a court, or two courts to be specific. Here recently, there was a Supreme Court case that allows USCIS, DOL, or any other agency to continue posting those rules because of a new way of the laws interpreted. So now we have what we call the actual final rule, which is derived from the IFRs from last fall. So they're not interim final rules any longer. They're final rules. And the good news is, again, that these are tabled for the time being. The two rules, in part, more or less correspond and work together as one. DHS, which is over USCIS, incorporated a rule that says who is an employer for an employer-employee purpose. So if an H-1B employee, which pretty much 90% of every H-1 works for an end client, is possibly not full-time, this new policy would say, look, the end client is, also qualifies as an employer. So now, based upon that definition, DOL adopts that, what DHS says is a new employer, and DOL now can require both employers to file LCA, both employers to file the H-1B petition. And, that would be very disruptive, because at the end of the day, what this policy was aimed and created to do is to go after the large Fortune 50 companies and say, look, let's say Apple, for example. Apple has employees that are there as software developers, and they're making $120,000 a year. And I have someone who's H-1B through a vendor or, through a consultancy firm, and they pay just like the prevailing wage says, they pay that person $94,000 a year, which is the legal requirement for like that position, let's say. Well, now, because of this dual filing, USCIS or DOL can now say, look, you're disparaging the workers, American workers, because these workers who are already at Apple make this much more, and you're using this temporary service for the actual employer pays much less. So we're going to fine you, or we're going to do something like that. So that's a real brief, explanation of what this means. And the good news is, obviously we were expecting it to be, set aside, but now we have confirmation it's suspended for another 60 days. And I'm sure they're going to start that process tomorrow to rescind these harmful rules.
Edmonds, as Biden said before, he started to implement the day one. I think it started to implement it. The first rule is suspended, maybe. Edmonds, do you think what the categories are, maybe what the immigration rules will implement in next 100 days? Edmonds, we saw in the public media saying that first he will do for undocumented Americans, maybe whoever staying American who are undocumented, he will do for naturalization within 8 years or something.
Mm-hmm.
Do you have the list? What is going to be done next 100 days?
I don't have the specific list. It's most of these concepts have been, more or less reported through the news media. So there hasn't been an official, today is the first day of the actual term. So there's not an official record that the president's issued at this time. But based upon what we know, there's multiple groups, including people who are backlogged for EB categories, right, that they want to address. And how they're going to have to address this, the president by himself just can't, sign a piece of paper and say, okay, now all the DACA kids have a pathway to citizenship. This is something that has to be done through Congress. So we're talking about, like what you and I have been talking about, Venkat, for 6 months now. We're talking about comprehensive immigration reform. This is something that is going to change the code by using Congress, both houses, both the House and the Senate, and then the president signing that into law. Now, between now and the first 100 days, there's a lot of debate, a lot of, we still have a lot of people with a lot of different views of what's the most appropriate way of moving forward with immigration reform. So all that has to be debated and planned, but it's very, very good news. So even though I know most of our listeners are hearing news about other groups or other situations, this is also going to incorporate, our listeners, and especially like the EB categories as far, as the backlog and all of that goes. So it's very good news.
Okay. So, excuse me. So yeah, you keep saying from 6 months, if Biden elected as a president, he gonna do some comprehensive immigration. That it means you already told that will give a right away benefit to the all employment immigration. So here, Lucas, I have a small question. So whatever I read or I see that he talking about the 1.1 million undocumented people within United States. So first he will take it up employment based or the undocumented.
I think you have to look at it all as a whole, because when you're talking about major changes to the law, it all has to be included probably, as much as possible. And that's where the comprehensive comes from. We want to change as much as we can and not just do piece by piece. So obviously there's a lot of people who have been, I know our listeners have all been waiting for many years, has had hardship in that way. But there's also other people that, might not be able to have a driver's license or might not be able to do other things because of the situation. So that, whenever the new plan is announced like this, I think that they usually get the headlines. But like I said, American Immigration Lawyers Association has already sent a pretty thick handbook of what we all want to see changed or issues addressed. And, employment-based immigration's in there. So, I think as far as like the news media, we don't want to be disheartened from not hearing specifically, hey, we have all these H-1Bs who are stuck in in this status and aren't able to change their status for many years. That's not as newsworthy, I guess, as, there's kids that are separated from their parents at the border, or people are being held in cages. That's more, I guess, what you would say newsworthy. So that's usually why we hear more of that. It's a headliner, right?
Yeah, that is a good information. Lucas, before going to the next question, I'm requesting to all viewers and listeners, you can post your question on YouTube or the Facebook comment page. So we will address your question and we will try to give the more information. And based on that, you can take a right direction and right step for your immigration process. Yeah. Lucas, the question, we step back to the DOL and DHL rule. It means January 15th, the Trump administration is released to DOL and DHL, the H-1B process for the consulting frame. This is also part of DOL DHL Final Rule, or this is the two different rules?
So that they're two different rules, but that's part of the rule we just discussed. So there's a lot of other small pieces in it, like the wage levels are supposed to incrementally increase like they were. There's supposed to be other, there are a few other caveats within it, but the main purpose of these rules is to go ahead and tie in these third-party offsite employments and try and I guess, in the mind of the agency to hold others accountable, And I think this is really a misnomer amongst the public. I mean, anytime that there's a chance for someone, a position to be full-time, usually the employer, it's better for them to have that person there full-time, whether it be an American or H-1B or whatever it might be. And, whenever we have these corp-to-corp agreements where a lot of people work, and, we all know these projects aren't necessarily long-term. They could be a 6-month project. It could be a year project. It's a short-term duration based upon maybe your skill set or what skills are needed and required at that time. And there's a lot of advancements we have with technology and industry and business that are done because this labor, this talent is available. And just because you make it hard for people to utilize that labor doesn't mean that now all these companies are going to go hire all the H-1B employees immediately. All it's going to mean is these projects aren't going to happen. So it's in the end, it's an economic loss for our economy, for society, and everything else. So a lot of these businesses that rely on maybe small projects that don't require someone staying onboarded as a full-time employee for multiple years.
Okay. So we are discussing about the DOL and DHL rule. The one is already you explained, but still I have a couple of questions on that one. Prevailing wages.
Sure.
Right. So this is also suspended as part of DOL DHL rule. But what about the perm application? Even perm application for the green card. So will it apply the same rule for the perm?
The prevailing wages, you mean?
Prevailing wages, yeah, for
Correct.
green card.
Correct. So the prevailing wages would be affected for both the perm, for the E3, H1B1, any other associated, visa category that would utilize the LCA. Okay. So any LCA that's utilized that pulls the data from OES would have that increased wage.
Okay. So how much it meant? This is you said that this is the suspended. Is it temporary, or the new administration come up with the new process or new rules, or maybe they might change the existing rules and come with any latest rules? What do you think?
That's a really good question. I think that there's multiple ways that we could go about this. So right now, just across the board, because the transition from one president to the other is usually pretty seamless. They help each other take over, and we have what we call a transition period. That was pretty much non-existent this time. So a lot of the new cabinet members are walking into situations they're not fully briefed on. They don't fully understand or know what's going on within each agency at the moment. So this moratorium on these rules allows everyone to have time to evaluate to see what's going on before we just make decisions ad hoc, right? Because we don't want to just wipe away. You never want the attitude of, I'm just going to cancel everything the other president did just because it's him. You want to analyze it and see what's best for, the agency, America, citizens, so on and so forth. And, that once they have a plan of what the good rules are, what the bad rules are, what needs to be changed or what needs to be completely revoked, there's different processes of going through it. So Congress, since these new final rules are so new, Congress can still go in within 60 days and vote on a resolution to remove these rules. The Senate, if they pass it, also and vote and pass it, then it goes to the president. He can sign it, and these new rules will go away. That's one method. Another method would be making a new rule to take away these rules through the agency, and they would have postings and notice and comment period. And another way would be with comprehensive immigration reform, Congress could legislate and write these things through as well. But the other way would be ignoring the rule, which up until this President Trump, that really never happened. But he did that with a rule that came through with Obama for this entrepreneurial rule, and they pretty much just disregarded it. So this is probably not the right procedure to follow, but I guess the president has been set that that's permissible. So I really don't believe that any of these rules will make it through.
Okay. So yeah, Biden maybe will bring the new immigration rules or maybe proposal comprehensive immigrations. You keep saying as comprehensive immigration that will benefit right away for across the US immigration community. So last year we saw this S386 bill is approved both, but there's a two different version. Finally, it got dead. So, do you think this administration will bring this kind of bills to eliminate the country quota? Do you have any information from ILA or?
Yes. So that is one of the major points that's going to be included with this comprehensive immigration reform bill. But we're not going to incorporate other bills that have already been, shelved more or less. And so there's no point. So you have to remember everything in the context of when it happens. We had a very much bipartisan period of time where we had in the House, it was Democrats controlling, the Senate, Republicans controlling, and nothing would, the two bills are not going to end up being the same or being approved even for the president to sign. So now we have, by virtue of the Georgia runoff elections, we have Democrats controlling the House, Democrats controlling the Senate by a slim majority, and we have the president also being a Democrat. So maybe there's concessions that were in the first bill that went through the House that maybe we want more. Maybe we, instead of saying removing the backlog over a period of years, why not just say with this new bill, we're going to issue 1 million new visas to clear up any backlog, and that way it's not phased in or phased out, and it's something that might be immediately available. That's why you and I were informing our viewers to, if at all possible, if you have the opportunity to go ahead and file your adjustment. Right now it's pending. I mean, maybe sometime this year we get the great news that everything's going to move much quicker and you end up with GC. So it's a thing that it's a once in a 10-year type opportunity. And, I wouldn't be worried. I wouldn't look to the old bills that kind of went off and died. I'd look forward to the new bills because they're going to offer probably more than what the other bills did.
Okay. I think this is the latest and updated on USA immigration or H1 DOL DHL rules. Lucas, we can go to the next. The segment is 485. There's from October. In October month applied a lot of adjustment of status. Do you have any update how the process is going on?
Yeah, we're receiving receipts that come through. Everything's processing. I already have some clients who've already received their EAD and advanced parole. And just to remind everyone, you have to go through your biometrics appointment. So depending on where you live and how many people utilize that facility might determine how fast or how long it takes to get the biometrics appointment scheduled. And then obviously once you get the biometrics appointment, you go and you finish that. It might be a few more weeks. So overall, we're seeing pretty fast movement in that regards for EAD and advanced parole.
Okay. In 485, just we observed, it means we got a couple of inquiries and the derivative applications.
Sure.
For kids, it means we got a couple of inquiries on kids. The primary applicant and wife got receipt number, but even kid did not get even the kid did not encash the check. So did we suspect, so do we suspect anything went wrong the application, or for kid only it will take maybe the kid application will take more time to process, or slow process we can say is the slow process? The what do you, do you have any information on that one?
I mean, things like this, if it's a kid, a spouse, or anything else, it could, depending on, it's a case-by-case basis for maybe whatever reason it might be. Maybe there's a delay in the issue of the receipts. Maybe there's issue where something wasn't filled out correct. I heard reports from IELA that a lot of people had wife and kids rejected because they weren't selecting that they were filing employment-based, even though they're not really filing employment-based petitions, but as a derivative, you still have to select that. That's one reason I've heard. It could be maybe the check wasn't honored. Maybe, I mean, there's many different reasons, and it's very specific, for each case. It could be something where a form wasn't signed, maybe. Maybe the check didn't have, when it was presented from the bank, maybe the funds weren't there. It could be any number of issues. So really it's a case-by-case basis. And, we'd have to reach out to USCIS to figure out, what that each reason would be.
Okay. But still, if I have a question about the still who did not receive the receipt number applied in October month, is there any way to find out their receipt number?
There is. You could go to Ask Emma on uscis.gov. You can ask that way. You could call customer service. Typically, you're going to be working with a customer service representative. So the people you're interacting with have maybe a little bit more access to a database to look up the information, but it's not going to be the same as if you speak to an officer. So unless the case is just freshly processed, they're probably not going to have any information. And there's still quite a few people, that we filed that we're still pending receipts coming in and everything. So it's just a matter of time. You have to remember and be patient that at the same time that every single family or person filed, there's 20,000 plus other people filed at the same time. So it's a huge amount of applications that were being processed.
Okay. Just maybe, I'm not sure you have this answer, just curious. Do you know how many applications got in October visa bulletin? Do you have any number?
I don't know the final number. I'm estimating is between 20, 25,000, but it could easily be more than that. But that's kind of what I was guesstimating based upon the previously approved I-140 chart that USCIS publishes.
Okay. Lucas, about the 485, we got a couple of questions. So we can take the questions and we can address the questions. Sure. We got one question from Mohan. Typically, this is the visa numbers. He's asking about the visa numbers. He's saying that this year employment-based visa numbers are 261K. Generally, it means 21,000 per month. We are in middle of January 2021. Means going to be completed almost 4 months. That means, shall we expect 80K members received GC under employment category this year, quota? Can we find court litigation on USCIS not to waste visa numbers?
So I think that USCIS is not going to waste the allocation of the visa numbers. At the same time, you have to remember, if you filed here recently, it's going to mean that you're still towards the back of the line in regards to EB2, EB3. So the numbers are still going to move slowly. Now, when we talk about comprehensive immigration reform, one of the principles we want to correct is if we have one principal immigrant filing, and he has a wife and a kid, that all three people count as one for the visa allocation. We don't, as of right now, that's 3 visas that are taken away. So that means the next person in line, if he also has wife and kid, that's 2 extra visas there, and so on and so forth. So it really limits how fast these can be issued. The visas can be issued, and how fast these categories move. So we'll know a lot more in the next 2 months or so. Trust me. And instead of focusing on our current system with the backlogs and everything, one key change I can pretty much assure everyone watching right now is that we are going to have something within this comprehensive immigration reform package addressing the backlog. And when I say address the backlog, I mean Congress has the power to say we're going to issue 1 million extra visas just for this purpose. And by doing so, it would clear the backlog. Okay. So instead of worrying about like, okay, I have my EAD right now and my visa gets current and then the dates retrogress and then next year it comes back and then they retrogress, we don't want people to be stuck in that scenario. So I really think right now this year we're going to see something, and it doesn't mean we're going to keep receiving 1 million, for example, extra visas a year. It's just to help take care of this backlog. And the math says right now we have someone who gets an I-140 approved today in EB2 from India. It's going to be about 70 years before the GC is actually available, which is just absurd.
Okay. So, Lucas, we can take another question we got from the Vinod. He's inquiring about the I-140 downgrade premium process. So he's asking about when is the right time to file premium process from the receipt date. What are the different scenarios in which is beneficial to file premium process and downgraded, and when it is not?
Well, Vinod, that's a very good question. I'm glad you brought that up. And I'll tell you my 2 cents of how this would be advantageous. Number one, if you downgraded and you
sorry for interrupting.
Am I there?
Yeah. Yes.
Sorry, someone's calling. If you downgrade, what's going to happen is you're staying with your employer or going back to a different employer, and maybe you are happy, maybe everything's fine. The benefit would be is if you could get your I-140 approved and your adjustment of status is pending for more than 6 months, it allows you to port your job to another employer without having to refile your labor, without having to refile adjustments or anything else. It's pretty much, you would just have to file a supplement J when your visa is available, showing that you still have gainful employment, that the position is same or similar to the original position that you petitioned for. So the benefit to that would be portability. If you're happy with your employer, if you don't really want to move or anything like that, there's really no benefit at the moment to go ahead and go through premium processing. It's more about planning to what your future might be, if that makes sense.
Okay. Let's say if you plan to premium, maybe process in premium process. So do you think we'll get any queries on that one, or will go smooth in process?
It just depends on each case, really. The most common RFE that you could get on this type of case would be especially if you go back to an employer you don't work for anymore and you downgrade, would be the ability to pay the wage. That's most common. Usually, if you're going from EB2 to EB3, the job posting that was in the perm is going to qualify for EB3 because the bare minimum, EB3 where it's just a skilled worker, or it's not a professional with a master's of 2 years or a bachelor's plus 5. So you could have bachelor's and only need 1 year, or whatever it might be. So it's more safe. The really the main RFE that you would see is probably going to be the ability to pay the proffered wage.
Okay. I think thanks, Vinod, for your question and bring in this show. This is a very important question. This is valuable for everyone who can take their application to premium process. Very up to them to whether they go to the premium process or not. Thanks, Lucas. Lucas, we go for the next question. We got from Ramesh. This is related to the 485 derivative. The primary applicant I-485 accepted and got receipt, but dependent application rejected due to the improper filing. You already told. The question is, can we reapply for the dependent even the dates retrogressed, or should we go for litigation?
You can refile. So what you would want to try and do, since the instructions are not clear on that, you'd want to probably try and file a nunc-pro-tunc, which would allow you to have them accepted because of that situation. I haven't come across any of those yet. I haven't tried that, but your attorney might be able to resubmit requesting that. As far as litigation goes, I don't know how we could proceed with a case. It would, it would have to. I'd have to look into that more as far as like to find out how you would have standing to move forward with that matter. But more than likely, the best thing to do is the agency to go ahead and reaccept the case that was filed. And then, like I said, there's a lot of people, from what I heard, that your spouse, they wouldn't select employment-based, or that she's a beneficiary of a I-140 or something like this on the adjustment of status application. That's the main cause of these rejections. So I would try that, and then also, hopefully with, that's all going to be moot in a couple of months, and it won't matter. So you can, hopefully refile even if they reject the case.
Okay. Yeah. Thanks, Ramesh. Maybe you can check with your attorney for the more information, or else if you have any additional question on top of it, you can send an email to Lucas, bg info@bgimlaw.com. Lucas will reply appropriate information to you. Thank you, Ramesh. Lucas, here I have one scenario. So I will explain first, then I will ask the question, give me the suggestion. We got from the Ravi. We got from Ravi. He worked for company A for almost 5 years. During his employment with company A, they filed GC under EB3 category by filling form in EB3. Then after he received EB3 I-140, he's a USA Master graduate. The second time, the company again filed form and I-140 under EB2 category. Before completing 180 days after receiving EB2 I-140, I think then he moved company B. He currently working for company B, and my GC form is under process. The here question is, his priority date was 2014 September. In 2020 October, when dates moved, company A said my position was still open and allowed me to file my 485 under EB3 category. With his previous approved EB3 I-140 under future employment, now he received 485 and EAD receipt last month. His question was, after I received EAD, should I go back to company A, or can I transfer my 485 to my current company B and continue my job? What challenges will be facing in transferring to B, and he is asking the recommendation. What would you recommend it?
I can't recommend, which company to do. So obviously, if company A, they filed your I-140, they never revoked it, then you filed based upon a current offer for future employment, you filed your adjustment of status. If that application using Supplement J, if that application is pending for more than 6 months, whenever you get an RFE for a updated Supplement J to show that the offer is still there, you can get that from company B, as long as the job is same or similar, in function. So really, until the visa is available where your GC is actually getting close to being processed, there's not much to really worry about at this stage. You don't have to be working for company A now or really anytime until after you get your GC. Then it's a good idea to probably work for them. But between now and then, when you get the GC, if you want to stay with company B, that's fine. And if company B would sign a Supplement J that would incorporate, where they take over the petitioning spot, that's permissible as well.
Okay, I think Ravi, you got appropriate information for your question. Still, if you want any information, you can send an email to info@bgimmlaw.com. Lucas will address your questions. Yeah, thank you, Lucas. And we have a couple of questions. Another from Pathak. So his question is: adjustment of status is filed on October 26 and he got receipt, but last week company announced layoff and his role might be impacted. So he said that I have a job until April 30. What if I join new employer early before completing 180 days from adjustment of status filing? What happens if before joining new employer, my I-140 downgraded does not get approved and also EAD and advanced payroll? His question is, what are options?
I understand. So the most important thing is that your I-140 is protected. So maybe this is a good example of wanting to get the premium upgrade and make sure your I-140 is taken care of. Because if your I-140 at the end of the day, if your I-140 is denied, obviously the adjustment application is going to be denied as well. So if in this scenario, if your company you're with, if you end up moving on to a different company tomorrow, it doesn't have to be when the I-140 is approved or anything else. If you get a different opportunity or you need to move on from this situation, you can. And as long as your I-140 is approved and not withdrawn by the current petitioner, a future company can go ahead and take the position. Now, I want everyone to remember this. Whenever we're talking 180 days, okay, the final action date would have to be current, number one, and you would be issued an RFE, or at the time of interview, you would just bring in the new Supplement J. It's not a hard and fast rule that on 181 days you're going to have to get a new letter or anything else. That usually, I've heard of people maybe going between one or two other companies before they actually have to go in for the final interview or the final RFE to show the Supplement J. So, really, I want everyone to have peace of mind knowing as long as you have this filed and you have I-140 and everything's taken care of, these provisions and these laws are meant to protect you as a worker. We don't want you to feel that you're shackled to one company or not have the freedom to move or make a career change. These laws are put in place to make it easy for you to make a choice that's best for you and your family to do what's in your best interest. So keep that in mind. And the most important thing, like I said, we have to have the I-140 approved. So if you have the chance and you want to upgrade, and this is a similar situation to what you might have, go ahead and see if you can upgrade. And then that way you have the peace of mind knowing that moving forward, your adjustment's still going to be active, even if it's with a different employer.
Okay. Thank you, Lucas. Pathak, I think you got information from Lucas. Maybe if you have any question in future, you can send an email to info@bgimmlaw and maybe you might clarify about your question in future. I hope you cleared on your question and you got information about your question. Lucas, we have another question from Vishnu. Yeah, this one is I forgot it asked before. We talk about the DOL and DHL, the final rule, and the H-1B process. What about wage level H-1 bilateral will be implementing CAP 2022?
Very good. I think we forgot that. We went straight to some questions.
Yeah.
So just like these other rules, the H-1B fiscal year 2022 CAP is impacted. As we've discussed in the past couple of weeks, this new rule proposes that we have more of a bidding system where we're bidding on higher paid wages, certain occupations, meaning certain SOC codes, certain geographic locations. These are all factors for that. And the harm for this is actually going to be that you can't, if I want to be wage level 4, my employer just to be selected in the lottery, my employer just can't say I'm going to pay you level 4 wage. You have to have some substantive evidence showing that the position actually is wage level 4, not so much just salary. So what does this mean? A typical software developer position requires a bachelor's degree at the minimum for the position, not for the person working there. We have to remember what the position is. So maybe the position says, I need someone with a bachelor's degree and 2 years of experience, working with J2EE or something like this. Well, that right there is just a wage level 1 job. If I say I need someone with a master's degree to work, with a background in J2EE, well, that moves it up to a wage level 2. Or if I have a bachelor's degree and 5 years of experience, that moves it up. So we add points based upon what the job duties and requirements are. So what a lot of people have to do is you're going to have to show why that wage level was selected was appropriate, much like how we did a few years back, how we had the wage level 1 issues. We had to prove it's still a specialty occupation, even though we selected wage level 1. This is this vice versa. It's the same thing, just on the other end of the scale. So that's one of the main things that's coming up. And I think really that, this rule is going to be, put aside. It's not going to be used. This is probably the easier rule to not use because of, the registration tool and everything else, the requirements to change, the requirements to add all this information. It would just be a huge burden to undertake.
And so already we are in January 20. Maybe we have the 2 months to apply. Maybe end date for the application for 2022 CAP. So do you think will implement it by March 20?
Well,
will take a process the previous year, CAP 2021.
You have to remember, like what we said in the first part of the show, this would also be what we call a comprehensive immigration reform. This would be something that could be addressed to say, look, maybe every year the CAP numbers are too low. There's too much demand for this program. Maybe there's too much visas available. Maybe they want to restrict it more. This is something that would be addressed and that they would address that point too at that time. So even if that does not happen, there's going to be court challenges that would put that aside, and there's really no basis in law for the agency to have come up with this rule to begin with. I do also want to, because it sounds like he is an F1 student, I want to bring this up real quick. Here recently, ICE has also implemented a new process or program through SVEP or CVIS also to do like a site visit check on OPT students. So most H-1Bs know we have virtual site visits now. You'll get a phone call or email from a FDNS officer. Well, that's going to be expanded now to OPTs, STEM OPTs, CPTs, to verify training, to verify what job you're doing, how it relates to your degree, and so on and so forth. So there's going to be a few changes. If you do receive any notice or any contact from someone from ICE, it's not to mean you're in trouble or done anything wrong. It's just a matter of collecting information.
Okay. Lucas, 1 second. I'm requesting all viewers, I'm requesting you, if you have any question, maybe you can post right away. We will take your question and address, or else maybe we will end show in within 5 minutes or within 10 minutes. Lucas, we discussed a lot of information about the Trump administration implemented the rules, and Biden, what is going to be proposed immigration. So the H1, so there's, if let's say the regular H1 exemption code or H1, what do you think? The wage level is same, the previous one, or it going to be changed, or is any rules got changed for the regular H1s?
Well, that's what we were saying at the beginning. The wage levels were going to incrementally increase. Like it's not going to be a drastic one day to the next, like it was in October, but they're going to increase by increments over a year. Again, I don't believe this rule is going to be around long enough for that to happen. And you have to remember, these Fortune 50 companies, big tech, that rely on most of these visas and assistance from people, like they don't, Google's, the Apples, the Microsoft, the Facebook, those companies, they don't want more restrictions on these visas because that would be harmful to their business. And they have a strong lobby where they can, pick up the phone and speak to people that are in Washington and really let their voices be heard because of, their political influence. But it's in their best interest also for this to kind of go away. So I really, like I said, I think it's an exciting time. I don't think we should be worried about, pending doom and gloom. I think we should really be looking forward to, positive change. And I do want to add this now that if no one else has any questions, just to close on this note from my side, we all want to make sure we reach out and communicate with our representatives, our constituents. We want to make sure you find out where you live and who your representative is for Congress. Email them, call them, let them know, hey, I'm here, I've been working for 5 years, I pay taxes. This is something important to me, and this is something that would help me. Same with the senator. U.S. senator, you can call them, email them, do as much as you can. That's how change is made for the most part to get a benefit. By sitting still and not saying anything or just waiting, it's going to be, many years to get any type of benefit, if at all. So the best thing we can do right now is, since all this is on the table, start calling, start flooding the office, and letting people know. We do know, I think last week, a new president was selected for the Telugu Association of North America. And, we obviously have the benefit of working with other organizations to help, speak for a whole group of people. But at the end of the day, if everyone spoke and relayed this information to their representative, we can really have, some positive change and address issues that need to be addressed.
Okay. Lucas, one is information. If anyone is interested to call to the senator or congressman, so if they want to send an email, if they come to us and ask about do we have any kind of template so that with the proper information, to send senator or congressman? Can we help them?
We can. That's not a problem at all to share templates. The best thing I can tell you is to write something personal from each individual means the most. We often request the help of representatives or senators. When maybe things are getting stalled within the administration, they'll help us go and push a case through, USCIS or whatever it might be, to help move it along. But at the same time, the representatives are here they want to help us. And if we have enough voices that are heard, that will help give insight. Because if Congress is going to issue comprehensive immigration reform, if the representative doesn't necessarily know that there's an issue impacting people, how are they going to know to fix that issue? You see, so the best thing to do is just to specify in your own words. Hey, I'm here. I live in your district. I'm on H-1B. I've been in this H-1B visa for 8 years. My employer wants to sponsor me for my green card, but due to so many people also applying at one time, this is delayed. And my kid's a U.S. citizen, and it gives us uncertainty in the future of where we're going to live long term, and it doesn't give us that security. Something like that. And each person, the more you have your own story in that, the more effective it's going to be.
Okay. Yeah. Thank you. Thanks for information. Yeah, I think we are attending the show today. You provided a lot of good information, and we discussed a very detailed information about Final Rule and DHL. Till now, we hear a lot of complicated rules and the immigration process. Going forward, every week we might be get good news every week. Hopefully, the Biden will implement the comprehensive immigration. Will it means all immigration community will benefited out of it. So hopefully he will do right way, and maybe he will take a process where he simplified the immigration process. So that's today, Lucas.
Okay.
Yeah, 1 second, Lucas. I think we got a one question from Facebook, Santosh. We take a last question. If we have both H4 EAD and GC EAD, which one should be held and why?
Oh, that's a good question, Santosh. Thank you for following us and watching the program. Really, what you want to do is maintain your non-immigrant status until we have GC in hand, if at all possible. So if you're already on H4 EAD and you get, GC EAD, the benefits of GC EAD are far greater than H4 EAD in the sense that it'll be renewed for only once every year. But right now, if you have H4 EAD and you filed it, but you haven't received the card before the expiration date, you can't work. On GC EAD, you can keep working with the receipt in your hand for 6 months. So if you can file a few, 6 months early for the renewal, and your GC EAD expires, you can keep working for 6 more months on the receipt. So it gives you more of a cushion, so you don't have that situation of losing your position waiting on the EAD card for H4.
Yeah. Thanks, Santosh, for your question. And also, we got a final question from Vilas. Vilas is asking that one of the students got EAD. Card is received at home, but it returned back due to unavailability at home. In this scenario, what is the process to get the student EAD?
You would want to contact USCIS, notify them of the card being non-delivered, and verify the address, and they'll resubmit the card. But you need to do it in a timely manner to make sure that the card's not destroyed. So go ahead and reach out, uscis.gov. You can call the 1-800 number for customer service. But either way is beneficial, and you'll be on the phone waiting for a little bit of time, but you need to do it ASAP so you don't lose the card.
Okay. Yeah. Thank you. Okay. I think we are at 7 p.m. I think ending the show. Thank you, Lucas. Thank you today having with Telugu NRI Radio. Do you want to share apart from this anything else?
No, I think that it's an exciting day. A lot of change is hopefully coming. I hope everyone's been able to appreciate the change that we've had. And I just want to again sincerely thank everyone for following us on our Facebook page, both Telugu NRI Radio and our office Facebook page. Also, if you have any questions, we're here to support the community. Don't be, afraid of asking a question, because I guarantee you there's probably 2 or 3 people similar to you that have the same scenario. And any other events that transpire with good news, we'll go ahead and try and have an immediate show or something like that to update everyone accordingly.
Okay. Yeah. Thank you. Thank you each and everyone who participated today, and especially thank for who sent their questions. We hope you got proper information from Lucas. So this show is very important. Primarily intention is to bring USA immigration and very detailed and transparency information, and reach out transparent information to the immigration community. We are trying to better day by day. You can post your questions or your topic on Telugu NRI Radio Facebook, or you can BG the Burgos Law Firm Facebook, or else you can send an email to bg@immlaw.com. We will take your question and topic and next the coming shows, and we will address your scenario. Will help to across the community. A lot of people, maybe the same scenario fall into the other person also fall into the same scenario, that will help to others. So we are encouraging to participate every Wednesday evening, 6 p.m. Central Time on Immigration Show in Telugu NRI Radio. Thank you very much, everyone, to participate in today's show, and we will continue this show every Wednesday, and we will catch up next week, the same time, the same show. Until then, bye, good night, good day. Thank you.